So we're on the record in docket 21-02458. That's people, the state of Michigan versus Ahmed Mohammed Meyer. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Meyer.
And Mr. Meyer is in the Ingham County Jail, or?
That is correct, Your Honor.
Okay. And sir, you are Ahmed Mohammed Meyer?
Yes.
All right. And you can hear me all right, Mr. Meyer?
Yep.
All right, thank you. This is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
Your Honor, it's my understanding the defense would like to file a forensic responsibility motion. People have no objection to the court granting that.
All right. And Mr. Goodrich, is that a fair statement?
That is correct, Your Honor.
All right. So if you want to file that. And it's just as to competency, correct?
Just
No.
as a responsibility.
Oh, just
It is
Just
not-
as to criminal responsibility.
Yes.
Okay.
And Your Honor, just to put it on the record, this case is a year old at this time. It's his previous attorney was preparing criminal responsibility and competency requests a year ago. Then Mr. Meyer missed court and had not been seen for 11 months or so. And in speaking with him, I don't believe competency is still an issue, though we believe at the time of the offense that he may have had competency issues that would lead to him not being criminally responsible.
All right. So in the order, it says the defendant shall undergo an examination relating to her criminal responsibility. That's not filled out, correct?
Yes, I left
You
that
left-
for you.
All right. And so the blank would be just for competency, correct? Other? Is that how am I reading that correctly? So there's an other here, and that would just be for criminal responsibility.
No, I believe
Okay.
this is where you're sending.
Okay.
So I believe you want to send him to the Center for Forensic
Okay.
Psychiatry.
All right.
Other would be some other type of medical
Right,
place.
so-
to
all right.
evaluate him.
I got it. Right, now sign the order. And then if you need a copy, you can get it from my staff. Anything else for the record in docket 21-02458, Mr. Wisty?
No, Your Honor, I would just inquire in this situation, is the court leave prelim on, or will that be held?
What's that?
When,
Oh.
just a responsibility.
I think we'll wait to hear back from when we get the report back, and then we'll reset it for prelim
Thank you, Your Honor.
because we're just not sure.
Right.
Mr. Goodrich, anything else?
No, Your Honor, thank you.
All right, that's all for the record in docket 21-02458. I'll make some notes in the file accordingly. But thank you for your appearance.
Yeah.
Mr. Ahmed, you're all set. The order's been signed. You can leave the Zoom courtroom.
All right. Thank you so much.
Thank you. Stephen Mammoth, all right. So we're on the record in docket 22-02722. That is people of the state of Michigan versus Camonte Deshaun Sanders. Will the parties please introduce themselves for the record?
Jake
Stephen Mammoth.
Whiskey on behalf-
What? Stephen
Jake
Mammoth.
Whiskey on-
Oh,
You first.
Stephen Mamet on behalf of the defendant.
Jake Wisty on behalf of the people.
This is the time set for a probable cause conference on Mr. Sanders' matter. Mr. Misty, how are we proceeding today?
Your Honor, I haven't had an opportunity to speak to Mr. Sanders' defense attorney. I would request a brief breakout room with him.
Mr. Mamet, would you be amenable to a breakout room with the assistant prosecutor? I know you had a breakout room with your client.
Right. I mean, I was simply going to ask for adjournment because I think we just got the discovery yesterday, and my client was prepared. I mean, we could speak. That's not a problem. But I would.
Your client was prepared to waive the 21-day rule?
Yeah, that's what I spoke with him about.
All right.
I would have no objection to an adjournment today, and then I can contact Mr. Labatt to speak.
That's fine.
All right, Mr. Mamet, may I inquire of your client to his right to a prelim within 21 days?
Yes, that's fine.
All right, Mr. Sanders, you understand you have a right to preliminary examination within 21 days of the arraignment. Do you understand that,
Yes,
sir?
sir.
And a
Yes, sir.
preliminary examination, and you are Comante Sanders?
Yes, sir.
All right, and you can hear me all right, right?
Yes, sir.
All right, perfect. And you understand that preliminary examination within 21 days is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You have that right under Michigan law. Do you understand that?
Yes, sir.
And you, of course, are represented by attorney Stephen Mamet and would be able to contest any charges or cross-examine any witnesses in regards to the state's witnesses at that preliminary examination. Do you understand that, sir?
Yes, sir.
You understanding that by waiving your right to a preliminary examination within 21 days, you will not be waiving your right to have a preliminary examination at all. You'll just be waiving your right to have it within that 21-day time period. Do you understand that, sir?
Yes, sir.
All right. Is it your intention today to waive your right to a prelim within 21 days of arraignment?
Yes, sir.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. We will reset the preliminary examination. Mr. Mamet, how many days are you thinking out that would be necessary?
14 to 21 days.
All right. That sounds reasonable, Mr.
Yes, Your Honor.
What's it?
November 3rd at 8:30.
Okay. We'll reset the prelim. Okay. He waived 21-day rule. And what's that date again?
November 3rd at 8:30.
So the prelim has been reset for November 3rd at 8:30. That's when we'll reconvene on the preliminary examination. Mr. Sanders, please keep in contact with your attorney, Stephen Mamet, if you have any questions, but we'll reconvene for preliminary examination in this court on November 3rd at 8:30. That will be live unless I hear different from the parties. All right, Mr. Wisty?
Yes, Your Honor.
Anything else, Mr. Mamet?
No, Your Honor.
All right. All right. That's all for the record, docket 22-02722.
Your Honor, the people also waive their right to.
Okay. All right. Thank you, Mr. Wisby.
All right. Thank
I
you, Your
assumed
Honor.
that was the case when you didn't object. So,
I'm sorry, I just wanted to make sure the record is clear. Thank you, Your Honor.
We're on the record in docket 22-01381 GC. That is Brittany Weaver, Travis Winters versus Brittany Lucero and Kayla Barrow. It's the time set for a motion to show cause. Will the parties please introduce themselves for the record?
Brittany Weaver.
All right, and you are Travis Winters? And you'll have to unmute yourself.
Yes, I am Travis Winters.
All right, and ma'am, you are Brittany Lucero?
Yes, sir.
And do you know where Kayla Barrow is?
No, I do not.
Miss
Kayla Barrow was removed from the file.
All right. She's still on our docket, but. All right, so this is a show cause as to defendants fail to appear in regards to a September 26th pretrial, it looks like. And that's, Miss Weaver, I'm assuming that concerns Miss Lucero?
Yes, Your Honor.
All right, Miss Lucero, you've been show cause for your fail to appear. What is the reason that you did fail to appear on September 26th?
It's because I was not served properly at all, and I was not.
Okay, I have service. In the file. What is your address? So your new address is on 807 Northeast Street?
Yes, Your Honor.
All right. And your previous address was 234 Haskell, Arkansas?
Yeah, that was a long time ago. That's my mom's address.
All right, that was the previous address I had.
Your Honor, she was served by a process server in Arkansas on September 11th, and they physically went to her house and gave her the paperwork.
Oh, was it?
I'm looking
That's-
for that in the court file right now.
I wasn't. Your Honor, they didn't even know my address until they stalked me to get my.
Well, if the court file and if the process server indicates under oath.
Yeah, they didn't know my
Yeah.
address. I was not giving out my address due to the fact of harassment. They have been
Say it
harassing.
again, Miss Lucero, say again.
I said I did not give out my address because all they do is harass me. They've been harassing me since I left Michigan of last year.
Well, how about this? How about we all show up in court and we decide what's going to happen in this case? Because I'm satisfied that you've met your show cause requirement. You're here now.
Yeah.
But now, so I'm not going to issue a bench warrant for you. All right. So, so I'm satisfied with that. I'm unsatisfied with where this case is going right now in regards to Zoom. I think that we probably should set some time aside to hear this case in person.
I love to do that, Your Honor, but I have no money because I literally live on my own and I don't have support from my kid's dad. He does not pay child support supposed to.
Miss Lucero, you can still come to court.
I can do Zoom, but I can't travel up there. I don't have no server.
You still live in Arkansas?
I've been living in Arkansas since last year.
All right, well, then so you're here now. What was the purpose of the pretrial then? Miss Weaver?
Your Honor, it was because we won the default judgment. And we were trying to verify where she is working so we can start the garnishment, so we can get what was awarded to us. We are willing to stop the garnishment. We would just like our property back. And Miss Lucero, the reason she doesn't want to come to Michigan is because she has an open warrant in the state of Michigan for domestic violence against Travis Winters.
All right, so here's the question. Miss Lucero, are you still in possession of property that is the subject of the suit?
The only property that is my property that they're saying that there's theirs when it's underneath my name.
All right, well, then it sounds like we need a hearing. All right.
Okay.
That it sounds like we need it, and it also sounds like all I'm doing is enforcing an order at this point. Is that your stance, Miss Weaver?
Yes, sir.
All right. So what is a Zoom date that we can set this for? Because I'm going to have to take some testimony on this concerning enforcement of the order. Because that's what we're down to, right? Is enforcing the order for purposes of transfer of property, correct?
Yes, Your Honor.
They're trying to take everything I have in my house that they never bought. That's hilarious.
You
Well,
need it.
Miss Lucero, you certainly have your chance to testify, okay, under oath.
Yeah, I know. It's just, I think this is ridiculous. Honestly, they just been harassing me. We have court date down here, December 5th of custody, and he's doing it because of custody. He's trying to take everything I have in my home that I purchased to take it away so that I can lose my girls. That's what it is.
Well, that's fine, but none of what you just said is under oath. This is all just a pretrial in order to get to a hearing, so you can say exactly the same thing under oath.
Okay.
You want it aimed for Monday, the 21st at 2:30?
Sure. So we're going to set this for a Zoom hearing for Monday,
November 21st
November 21st
at 2:30.
at 2:30.
Your
And
Honor,
at that
would you,
time, go ahead, Miss Weaver.
would you like me and Travis to appear in person?
If you
Instead of on
choose to,
Zoom?
if you choose to, it's up to you. Since we have a Zoom hearing, it's completely up to you. But if you can, I would indicate that everybody bring whatever evidence you want the court to consider for enforcement of the order, which is what this hearing's about. And everybody will be under oath whenever they provide evidence or testimony in regards to the order. It's simpler to do it that way and then to come out with a decision than to do it at a show cause hearing on a Friday morning when that wasn't everybody's intent. Ms. Lucero has satisfied the court that a bench warrant's not in order here. However, I would like to have a hearing on this motion to enforce the order in regards to everybody being under oath. Do you have any questions of me, Ms. Lucero, on that November 21st at 2:30 date?
Yes. How would I show my side? Like, would I be able to send it to you?
Yes, you send it to me and send it to Miss Weaver. Send it to opposing counsel. If you would like, if you have some concerns, you can send it to me and we'll provide it to Miss Weaver.
Yes, that would be really appreciated.
All right. So any evidence you want us to consider, I understand you're out of state, send it to me and we'll make sure that Miss Weaver gets this. We'll have a hearing under oath and then I'll come to the decision on the order, okay?
Okay, thank you.
All right. Anything else, Miss Weaver, on docket 22-01381?
No, Your Honor. Thank you.
Mr. Winters, anything? All right. That's all for the record in the file. I'll see everybody back on November 21st at 2:30.
Thank you.
2:30, right? All right. Thank you. That's all for the record in this file. record in docket 2202-691. That's people of the state of Michigan versus James Harold Lilly. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Lilly.
And sir, you are James Lilly? All right. This is the time set for a preliminary examination. Mr. Wisty, how are we proceeding?
It's my understanding the defendant will be unconditionally waiving his right to a prelim. People will also waive their right. An offer has been made where Mr. Lilly could plead to either count 1 or count 2. In exchange, the remaining count would be dismissed.
All right.
That is all correct, Your Honor.
All right. So this is a waiver of the preliminary examination in district court. And then the offer, which will follow.
Would be he can plead to either count 1 or to count 2. The remaining count to be dismissed.
Is that your understanding, Mr. Goodrich? The offers a 1-for-1 in circuit court at this point in time, and he's going to waive his right to preliminary examination today.
That is correct.
All right. May I inquire of your client of his waiver of his preliminary examination?
Yes, Your Honor.
All right. Sir, you understand that you have a right to preliminary examination in these 2 counts in district court?
Yes, Your Honor.
Okay, and preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in this file. Do you understand that?
Yes, Your Honor.
Okay, and you of course are represented by Mr. Goodrich from the Public Defender's Office, and he would contest any charges and cross-examining any witnesses that the state brings against you. Do you understand that?
Yes, Your Honor.
It's my understanding that you wish to waive your right to a preliminary examination in this case, go on to circuit court where the case will proceed. Your time in district court would be finished. There is an offer on the table of a 1-for-1, plead to 1, dismiss 1, but negotiations would continue in circuit court. But that is the offer at this time. Is that your understanding?
Yes, Your Honor.
Is it your wish today to waive your right to a preliminary examination in district court?
Yes, Your Honor.
All right, thank you, sir. Mr. Wisty, I assume that the people are also waiving their right to a preliminary examination?
Yes, Your Honor.
All right. I find the waiver to be done freely, understanding, and voluntarily. We've spoken about the plea agreement. So I will bind this case over to circuit court on the waiver. Anything, so keep in contact with your attorney, Mr. Goodrich. He'll provide you with any dates that you have to appear for in circuit court, okay?
Okay.
All right. Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor.
All right, we have some paperwork for you to sign, sir, on the waiver.
I can't hear anything.
I will be with you, Sean, to borrow your pen.
Miss Allen, we'll be with you in a minute, okay?
Okay.
You're good.
All right, Mr. Williams, Miss Allen, we're going to place your case on the record. This is docket 20-01986. That's people of the state of Michigan. I'm sorry, that is Security Credit and Services. David Williams Credit versus Sharonda Allen.
That's not me.
Oh, that's not you, ma'am. Oh, you're here on your probable cause hearing. Mr. Williams, do you
that's
see
me.
the defendant? You are David Williams, sir? I can't hear
No,
you,
but
sir.
I'm on that case. Security
Okay.
against Allen.
Bradley Johnson. David
All right.
Williams has a PCC.
All right, so there's David Williams has a PCC. So Mr. Williams, you're here on the Security Credit Service case, correct?
No, Mr. Johnson is.
I'm sorry, Mr. Johnson.
Correct, Your Honor.
All right, so they're all lined up, and I'm trying to figure out which ones are the PCCs and which ones are the civil. So that's a security credit, and that case was set for 8:30, and the defendant in that case is Sharonda Allen.
Correct, Your Honor.
All right. All right. Well, it is now 9. I have a 9:11. It appears that Miss Allen has failed to appear. This case was set for 8:30. It is now 9:11. Mr. Johnson, how would you like to proceed today?
Your Honor, I'd request that her motion for installment payments be denied, not only because she failed to appear today, but also because she is literally just defaulted on a prior installment payment order that had to be set aside.
All right. Well, this was an objection to an installment plan, correct?
Correct, Your Honor, yes.
All right. So I'm going to indicate the defendants failed to appear. The objection to the installment plan is denied. So the installment plan is to continue.
Huh? Your Honor, I want the installment payment plan to be, or her motion not to be granted.
Right. So her objection, your objection is denied, or your object. I see what you're saying. The object. So, well, her object. She objected to your installment plan, correct?
No, she proposed, she's being garnished. She proposed the installment payment plan. However, she literally was on an installment payment plan prior that had to be set aside due to a default. So my position is the only way this is going to get paid is through a garnishment.
All right. So the default should be reinstated, so to speak.
The garnishment should continue. So if the order for installment payments says it's denied, then it just please deny the motion.
All right, so the motion to change is denied. The installment plan, which is according to what you're indicating, which makes sense to me. I have this as an objection for the installment plan to continue. That's denied. And so the original installment plan continues, and then it appears that it's a collections issue.
The prior installment payment order, you set it aside. So there is no installment payment plan. She
Okay.
filed a motion to get another installment payment order to stop this garnishment. I'm asking that the motion be denied and there's no installment payment plan. There isn't now, and I don't want one going forward.
All right. All right. I think we've said the same thing several times
Okay.
in the same way. But
Okay.
the motion, the objection's denied. There's no installment plan per the court. And then I guess you're in a collection situation at this point.
Correct, Your Honor. Thank you.
Anything else for the record in docket 20-1986, Mr. Johnson?
No, Your Honor. Thank you very much.
All right, thank you. That's all for the record, 20-01986.
All right, thank you.
All right, we're on the record in docket 22-02705. This is People of the State of Michigan versus David Williams. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Sir, you are David Williams,
Yes, sir.
and you are unrepresented. You are unrepresented today. Is that correct? I can't hear you, sir.
Sir.
I still can't hear you, sir.
Yes. You hear me?
All right. I can hear you now. Have you applied for, my understanding is you applied for court-appointed counsel and you were denied. Is that correct?
I'm actually not sure at all.
Okay. Our records would indicate that you were denied court-appointed counsel at this point.
Okay.
Do you plan to seek representation in this matter? You're set for preliminary examination on October 28th at 8:30 next week.
Yes.
All right. And you're gonna do that? You're gonna seek representation on your own in this matter?
No.
Right. So I guess I'm a little confused. How are you gonna get representation in this matter?
Public defender.
All right. You've already been denied by the public defender.
Oh, I've been denied. Okay, well then by itself then.
Good. So you're gonna seek representation on your own.
Yes.
All right. I'm gonna leave this on for next week at this time, I guess. And that's you have 1 week. Your preliminary examination is October 28th, 2022. You have 1 week to get a lawyer. Share with that lawyer the date so that you can have representation at the preliminary examination. Do you understand that, sir?
Yes, sir.
All right. Once you find out what lawyer you're going to get to be represented, you should share that with the assistant prosecutor, Mr. Wisty, so he can have some contact with the lawyer. I don't want you to have contact with Mr. Wisty if you're seeking legal representation right now. I think it puts him in a different position, mostly because you intend to be represented in this matter, and it wouldn't make sense to put you in a room with Mr. Wisty if you plan to seek counsel. Do you understand that, sir?
Yes, sir.
All right. So the date, anything else, Mr. Wisty, on this?
No, Your Honor.
You could meet with him, but I just see if he's seeking counsel, what's the point on some level? All right, Mr. Williams, we're gonna leave your preliminary examination on for October 28th. You should show up in person to this court with a lawyer, all right?
Okay.
And as soon as you find out who your lawyer is in this matter, you should have him contact Mr. Wisty at the Assistant Prosecutor's Office, okay? At the Ingham
Yes,
County
sir.
Prosecutor's Office. Do you want me to repeat any names or dates for you to take down?
The person's name, you said Mr. Whiskey?
Yeah, it's Jacob Wisty, Wisti.
Okay, I got that.
And the preliminary examination date is set for October 28th at 8:30.
Yes, I got that on my paper still.
Perfect. All right. And that'll be live in person. Anything else for the record in docket 22-02705, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Williams? Do you have any questions of me?
No, sir.
All right. We'll see you next week. All right.
Yes, sir.
All right. Thank you. You're all set to leave the Zoom courtroom. And sir, you are Robert Johnson,
Yes, sir.
and you can hear me all right, Mr. Johnson?
Yes, sir.
All right, this is the time set for a probable cause conference. Mr. Wisty, how are we proceeding today?
Your Honor, the people would like this left on for preliminary examination.
Mr. Abbott?
I understand. I received some communication from Mr. Wisty yesterday. I also spoke with Mr. Johnson last night, and we're prepared to proceed to the preliminary exam next week.
All right, Mr. Johnson, that's your understanding. We'll be proceeding to the preliminary examination on October 28th at 9 a.m.
Yeah.
All right, so we'll leave this on for prelim on 10/28/2022 at 9 a.m. Anything else for the record, Mr. Wisty?
Nothing from the people. Your
Anything,
Honor.
Mr. Abbott?
No, thank you.
All right, Mr. Johnson, we'll see you next week at 9 a.m. on October 28th. All right, sir? All right. All right, we're all set. If you have any questions, keep in contact with your attorney, Mr. Abbott, all right?
All right.
All right, you're free to leave the Zoom courtroom. Thank you, everybody, for your appearance. That's all on 22-02744.
I don't know if it has counsel, I just have a quick email to the staff to see if it can.
All right. And Mr. Sarks is here on Mr. Feigel's case. Have you gotten any word back on? I can, let's go ahead and call him and I'll
I haven't gotten a denial or an
On a
appointment.
point.
I haven't gotten a bill.
He's gotta be in another court.
So I mean,
How about Miss, oh, that's Mr. Nickel. So, Miss Allen, we are just waiting for your attorney who's in another courtroom to appear in order to call your case, all right?
Okay.
Mr. Tate, are you represented by counsel today?
No, sir. I'm still seeking counsel.
All right, we're on the record in docket 22-02665. People of the state of Michigan versus Raheem Tate. Will the parties please introduce themselves to the record?
Jake Westy on behalf of the people.
And sir, you are Raheem Tate?
Yes, sir.
All right. This is the time set for a probable cause conference in this matter. My first question, Mr. Tate, did you apply to the public defender's office?
Yes, at first, but when I found it out, I was looking for my own representation, sir.
All right, so you initially looked for your own representation, but you did make application to the public defender's office.
Yes, I talked to him when my first court date.
And you have not heard back from them at this time?
No, sir.
All right. So you do plan to be represented at the preliminary examination by the public defender's office or by your own counsel if you're denied the public defender's office. Is that correct?
Yes, sir.
All right. So go ahead.
No, but I was saying that I was actively still looking for my own lawyer also.
All right. Well, at this point in time, since you don't have a lawyer and this is a probable cause conference and you're seeking counsel, I'm going to leave this for preliminary examination on October 28th at 9 a.m. We'll just leave it on for prelim at this time, okay?
Yes, sir.
So, okay, my understanding that we just checked with the public defender's office and that you at some point you declined representation with the public defender's office. Is that correct?
Yes, sir. Because I was
All right.
I was supposed to have a lawyer.
All right. So your plan now is to seek representation on your own.
Yes, sir.
All right. So I'm going to leave this set for prelim for October 28th, 2022 at 9 a.m. So you want to write down that date, or that's probably on your notice, but October 28th at 9 a.m.
Yes,
Any
sir.
lawyer that you get to represent you for that date, they'll want that date. And then you should give them this name as a contact person with the Ingham County Prosecutor's Office, all right?
Yes, sir.
The name is Jacob Wisty.
Jacob Whiskey.
Wisty, W-I-S-T-I.
Yes, sir. Is it okay that I get up to grab a pen?
Sure, yes it is.
Oh, thank you. Oh, can't go too far. Oh, here we go.
So
apologize.
have your lawyer contact Jacob, J-A-C-O-B, Wisty, W-S-T-I.
W-I-C-I.
S-T-I.
Yes, sir. Jacob Whiskey.
And Wisty, yes. And we'll have you back. So I'll see you back here on October 28th, 2022 with council present. Okay, Mr. Tate?
Yes, sir.
All right. Anything else for the record? Docket 22-02665, Mr. Wisty?
Nothing for the record, Your Honor. It may be prudent to give Mr. Tate the number to the public defender's office in case he fails in obtaining.
All right. Just in case you want to reapply to the public defender's office or seek, would you like their number?
Yes, sir.
What's that?
Yes, sir.
All right. The number there is 517
Yes.
679
679.
2979.
Yes, sir. I appreciate it.
All right. That's all for the record, docket 22-02665. Mr. Tate, that hearing right now, it will be live unless you hear differently, okay?
Yes, sir. So it's in person or on Zoom?
In person.
Yes. Yes, sir.
All right. Thank you. That's all for the record in this file.
All right. Have a good day.
You too. You're free
Yes,
to
sir.
leave the Zoom courtroom, sir.
Yes, sir. Just like they told Shady. This is ridiculous.
Miss Allen? Miss Allen, can you unmute yourself, please?
Yep, I'm unmuted.
Okay, your attorney just finished up in the other courtroom. He's gonna hop in on Zoom and we're gonna put you in a breakout room so you can have a meeting with him privately, okay?
Okay,
So in a couple minutes, you'll get a prompt that says join breakout room, so just hit the prompt when it comes up, all right?
all right.
Okay, stand by.
There she goes. So we're on the record in docket 22-02642. There is an accompanying file of 22-025, I'm sorry, of 22-02165GZ with this file. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender, covering for Stephen Mark Feigelson, the attorney of record on this file. Here on behalf of Lana Ward, she's present. She's at council table. She's seated to my right.
All right, ma'am, you are Lana Ward? All right. This is the time set for a preliminary examination, Mr. Wisty. We've had some discussions in chambers. How are we proceeding today?
Your Honor, we'd be adjourning this matter. This was scheduled for a plea. We've got some more information regarding the ownership of the animals, part of the plea negotiations, where Ms. Ward was to forfeit the animals. It appears she may not be able to do so. People believe an adjournment is appropriate given the circumstances.
Mr. Sarts?
Thank you, Your Honor. I agree, and Ms. Ward is agreeable to waiving her timeline and resetting this prelim out for a few weeks. I think it might make sense to maybe set this out for about a month or so, and in light of the somewhat unusual circumstances here.
I agree. May I inquire of your client of the waiver of the 21-day rule?
Yes, Your Honor. Thank you.
Ms. Ward, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Your date of arraignment was October 3rd, so you have a right to a prelim within 21 days of that date. Do you understand that, ma'am? And at that preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime was committed in this file and the identity of the person who committed that crime. Do you understand that, ma'am? And you'd be represented by Attorney Steve Feigelson. Mr. Sarts is stepping in for Mr. Feigelson today because he's in trial. And Mr. Feigelson would contest any charges or cross-examine any witness brought against you by the people of the state of Michigan. Do you understand that? All right. Is it your intent today to waive your right to a preliminary examination only within the 21-day period? You're not waiving your right to a preliminary examination in general, just to have your rights, just to waive it within 21 days.
Yes.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. Mr. Wisty, you're also waiving your right to a prelim within 21 days?
Yes, Your Honor.
All right. And so this case is adjourned. My understanding is that the subject of the plea agreement is debatable concerning whether it can be performed today. There may be another party involved, and that party should seek legal representation just to understand their rights in the case. I think that's important. All right. All right. So we're going to reset this. Yes,
I haven't
we're
found
going
him
to put them both together.
November 23rd at 8:30 because of Wednesday before Thanksgiving.
November 23rd at 8:30. Which is the day before Thanksgiving.
That's our prelim day.
But
that week.
that's our prelim date, so we're gonna set it for then. So Mr. Wisty and Mr. Feigelson, I will see you on November 23rd at 8:30. Miss Ward, I'll also see you. Okay, ma'am?
Yeah.
All right. Thank you.
Thank you.
That's all for the record in docket 22-02642.
Awesome paperwork in just a minute.
All right, and then I will.
I'll go down to talk to Mr. Walker.
All right.
Here's the first one. And now you're gonna do some math.
And then I'm gonna go ahead and make some notes in the company.
Yeah, I'm working on it.
Yeah, I gotta figure it out.
There's the civil and there's the criminal on that file. And Mr. Nickel, you ready to go on Miss Allen?
Yes, Your Honor.
All right. So we're on the record in docket 22-02594. That is the people of the state of Michigan versus Sean Allen. Will the parties please introduce themselves for the record?
Jake Whisty on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Miss Allen, who is present over Zoom.
All right, and you are, ma'am, you are Sean Allen, ma'am?
Yes, I am, Your Honor.
All right, you've been waiting patiently today. You can hear me all right, ma'am?
Yeah, I can.
All right, thank you. This is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
Your Honor, we'd like this left on for the preliminary examination.
All right. October 28th at 9 a.m. And Mr. Nickel, that's your understanding?
Yes, and just one thing so the court's aware, Miss Allen is currently experiencing some medical symptoms. She's sick. She's had a visit with a doctor. She tested negative for COVID, but they believe she likely has it.
All right.
So they've advised her to test again in a few days. If she tests positive, I will of course let the court know.
Let us know. And
I assume the court doesn't want a COVID positive individual coming into
right.
court.
We'll respond accordingly. Yeah. All right. So Ms. Allen, you are set for prelim on October 28th at 9 a.m. Let your attorney know the results of any health tests that you take, and then he will apprise the court of the same, and then we'll make accommodations from there. Okay, ma'am?
Okay.
All right. Anything else for the record in docket 22-02594, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Nickel?
No, Your Honor.
All right, Miss Allen, we'll see you next week at October 28th if all turns out correct. Okay.
Okay. Thank you.
All right. All right. Thank you. Thank you for being so patient today.
Uh-huh.
Sorry. So we're on the record in docket 21-02767. That is people of the state of Michigan versus Jacob Farenbrook. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And Scott Nickel on behalf of Mr. Fahrenbruch, who is present and standing to my right.
And sir, you are Jacob Farenbruch?
Yes, Your Honor. Fahrenbrook, Your Honor.
Farenbrook, thank you.
Yes, sir.
This is the time set for preliminary examination. Mr. Wisty, how are we proceeding today?
The people would be requesting an adjournment, Your Honor. We believe good cause exists. Trooper Mater, who is a necessary witness here, he conducted a true narc of the controlled substances, is on vacation. He is in Kentucky for a cattle show. He'll be back early next week. I would cite two people. The Horn 147 Mish Ave 375, 1985 case. That case found that essential police officer witnesses being on a pre-planned vacation constituted good cause. I would request an adjournment, Your Honor.
Mr. Nichols.
So I think the issue is, I don't know that it's necessarily a problem to adjourn it, because it would not, my discussions with Mr. Fahrenbruch, it would not be his intention to run this exam. His intention is to accept a sobriety court offer, which my understanding, discussions with the other attorneys involved, would lead likely to a dismissal of this case as part of that deal to get him into sobriety court. The only issue would be Mr. Fahrenbruch would be requesting that the court modify his bond to be a PR bond so that he can be released. He understands that he had failed to appear in the past in this file and understands the prosecution's concerns. But based on where Mr. Fahrenbruch is now, he has a lot to lose were he to decide to start missing court hearings. He is facing felony counts both here in 55th, here and in 55th. And he's got a deal that will resolve those. We'll get him into sobriety court. And I know this court is, but certainly Judge Allen as well, and with sobriety court participants, is zero tolerance. And we'll take that very, so he's got every motivation to appear to get this case resolved. He has been working with CATS and other programming at the jail. He's filled out and done everything he needs to do as part of that screening process. It's now just the probation staff at 55th needs to finalize their side of things and confirm that he is eligible. And then once that's confirmed, there will be a plea and sentence date, I expect, set in front of Judge Allen. So we wouldn't necessarily be objecting to the adjournment, but we would be requesting that he be allowed to be released on a PR bond at this time.
All right, well, first we'll deal with the adjournment, and then we'll deal with the PR bond, okay? So you have a right to a preliminary examination within 21 days of your date of arraignment. That your date of arraignment was October 5th, 2022. Is it his plan to waive the right to a preliminary examination within 21 days as a part of the adjournment?
Exactly.
Yeah, I believe so, because he wants to be screened. He wants that.
I would assume he wants to be screened.
Yes, Your Honor.
Your Honor, we requested the sometime after November 1st. That's his next court date, 55th.
Okay.
If it's set past that date, we should have an answer by then.
All right. So the requirement may inquire your client of the waiver of 21-day rule.
Yes.
All right. Mr. Fahrenbrook, you understand you have a right to a preliminary examination within 21 days.
Yes, Your Honor.
And part of that preliminary examination is a probable cause hearing. Probable cause that would have to be shown by the people of the state of Michigan that a crime was committed and the identity of the person who committed the crime in the file. Do you understand that?
Yes, Your Honor.
You, of course, are represented by Scott Nickel. He would contest any charges and cross-examine any witnesses that are brought against you in the case. If you waive your right to a preliminary examination today or within 21 days, you'll only be waiving your right to a prelim within that 21-day period. You won't be waiving your right to a full preliminary examination. Do you understand that?
Yes, Your Honor.
Do you waive your right to a preliminary examination within 21 days today?
Yes, Your Honor.
Okay, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. We will reset this so the prelim will be reset.
November 3rd at 9.
It's got to be after the first, you said?
Yes. So I think the 3rd would be
So
sufficient.
I think the 3rd would work, yeah.
At 9.
So November 3rd at 9 a.m. At 9 a.m. or prelim. And then I believe Mr. Nickel, so that's all from the record concerning the preliminary examination. Now, as to bond, Mr. Nichols made an argument, I understand it. Mr. Whiskey, any response?
Yes, Your Honor, I would oppose any bond modification at this time. Well, he's in the process of screening. The treatment court or sobriety court deal is not a done deal at this time. Based on what was publicly available as of yesterday, in addition to the matters we have here in Ingham County, he's got $1,000 hold for Eaton, $2,000 in Oakland. I don't have any further information on Eaton. The Oakland hold, I believe, is for a retail fraud. And he may have never been served with a complaint on that from what I can tell. The history in this case, this started a long time ago. December 29th, 21, he had waived the timeline for the non-prelim in this case. Then he appeared via Zoom for a prelim after it was rescheduled. There was some argument with the judge whether or not he had to appear in person or by Zoom. He was told he had to appear in person, and he never returned from that court date. The 55th, it looks like what I've got on December 23rd, 2020. He did not appear for a prelim. It looks like someone was able to talk to him over the phone and advised him he was able to log into Zoom and wait for 21 days. And he never logged in on there. Failed to appear again for another prelim on 1/4/2022. On that one, I know it's indicated he advised he was ill. He also had missed the assessment for sobriety court then, and a bench warrant was issued. Bench warrant was in status until 9/13/2022, when he waived the 21 days there. And then on January 3rd, 2022, he had a pretrial on a misdemeanor case. There's nothing then until 10/4/22. I think there may have been a bench warrant on misdemeanor as well, but I don't have confirmation of that. I believe his past behavior indicates that he would be a flight risk if he was released, Your Honor, and I don't think any bond is appropriate at this time.
Mr. Nichols, your response. I know you made the motion. I did not even look at the second page. I didn't even have to waive the 21-day rule, since he probably waived it on December 16th of 2021. So thank you for letting it. So I went through that exercise. This file dates back to October 5th of 2021.
Yes.
So Mr. Nichols.
So as far as the failure appears, Mr. Fahrenbach would dispute some of it, but understands that he did miss hearings. He's acknowledging those are poor choices that he made, and just would ask the court to understand that he is mentally and psychologically and sobriety wise in a different place now than he was then. He is motivated to appear at these court hearings and get sobriety court resolved. He's got that screening done. He's got a hearing on November 1st. He has PR bonds everywhere else. And my understanding from Mr. Fahrenbruch is that the Eaton County matter, he was arraigned, pled, and sentenced to time served on that matter. So that is closed. And so this literally is the only thing holding him. I understand the prosecutor's concern, but I would ask the court to give him an opportunity to get out, continue to get things in order so that he is ready, fully ready and stable when he enters into sobriety court, which is his, and he will be able to return to full-time employment once he is released.
Thank you. Anything else, Mr. Wilson?
Your Honor, I would just say, obviously that's accurate. Once he's in sobriety court, he should be released. I would believe it's more appropriate to wait till we have the results from the screening and an official.
I agree, Mr. Fahrenbrook. Unfortunately for me, I have some knowledge about the cycle of drug addiction in regards to methamphetamine and ecstasy, not only based on my experience on the bench thus far, but based on familiar family matters concerning the same events. Okay. I think you need to be screened. I really do. I think you need to be screened, and I think that I'm helping you in making sure that you're screened and not out, because I fear of what's available when you're out.
Your Honor, may I speak?
But you may, but let me finish.
Yes, sir.
And I know what you're going to indicate to me, that you're
No.
going to indicate that you're in a different place and you feel better and all these things. And I know it to be true, but I'll feel better if you're screened and we understand you're attacking the problem that's going to be a problem for the rest of your life, not just for today, not just for tomorrow, not just for 2 weeks from now. It's going to be a problem the rest of your life. So feel free to speak, sir.
Your Honor, last time I was convicted of a charge was 2011. I have over 10 years of sobriety. Drugs and substances mean absolutely nothing in my life whatsoever. I recently lost my father. I have been driving fork trucks since I was 13 years old. I've worked my whole life. During COVID-19, I fell into a dark place due to the loss of my father. I made a severe mistake. That I have to be held accountable for my actions. But methamphetamines, substances, alcohol, tobacco mean nothing in my life whatsoever. My grandbabies, my wife, my service dog, my mom, which resides in Colorado, that just beat cancer, are the only things that mean anything to me in my life.
All right.
There's nothing in this world that can cause me to relapse or put another substance in this healthy body of mine. I'm 41 years old, and I can't stress to you enough that I made a severe mistake. I'm paying the ultimate punishment for it now.
Well,
But there's nothing that anybody can do or say to me to cause me to relapse, to drop dirty, to miss a court date, period.
all right. I understand that. I think being screened and going through sobriety court, going through Judge Allen's court is the best thing that could
I've
happen
been
to you right now.
incarcerated already for 3 months.
Right.
And
It's a 10-year felony, sir. It's a 10-year felony. So I'm going to deny the motion for reduction of bond until screening. I assume after screening, this will be readdressed. But I just want you to be screened. That's what I want.
when I get screened, do I get released from jail? Because
If Mr. Nickel brings a bond reduction, we'll reassess the whole. As a matter of fact, I think that the prosecutor said, once you're screened, it's good to go. And the history of this case is
keeping me
case
incarcerated is going to hurt my life more than allowing me to go back to work into my family.
right, but screening will
No.
ensure
It's
that you're a good
backwards.
candidate for
It's
this.
backwards, Your
All
Honor.
right. So the bond reduction is denied, and I will revisit it, or we will revisit it after screening. Okay.
He doesn't know me. He
All right.
doesn't understand my life. I made a
Thank you, Your
relapse.
All right. Thank you,
Mr.
Mr.
Honor, for your time. I do appreciate it.
All
Mr.
right.
Flores.
Thank you.
Thank you, sir.
In docket 22-02598. That's people of the state of Michigan versus Ashley Burchett. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Ms. Burchett.
This is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
Your Honor, it's my understanding the defendant isn't here and the people would be requesting a bench warrant.
Mr. Nichols?
It's my understanding Ms. Burchett is not here, although it's my understanding that her husband may have been here earlier without her. I would, rather than issuing a bench warrant at this time, I would ask the court to consider treating the PE next week like a PCC to see if I'm able to get in contact with her. I have left messages with her, just simply waiting for her to reply. I was able to locate an email address, which I will send an email to. But if we treat that as a PCC next week, Mr. Wisty would not have to have witnesses come. And then if she does not appear at that time, we can address the issue of a bench warrant.
Response?
If we set the 48 hours for to appear, this being a Friday, does that run until?
I would give her a certain time. So within 48 hours, I would say if she appears by Monday at 5 or Tuesday, let's do Tuesday at 5.
Tuesday at 5.
Let's do Tuesday. It's a UNP case, so it's not a violent felony. If she appears before Tuesday at 5, then there'll be no bench warrant. We'll just leave it on.
Okay.
If she doesn't appear by Tuesday at 5, we have to bench warrant her. And so
And then I would no. Okay, thank you, Your Honor.
so place hold on bench warrant until Tuesday at 5.
And I'll let Nathaniel and Wendy know if she does contact me, so we can at least get her in front of Your Honor to address that issue.
All right.
Prelim will remain as scheduled.
Prelim is remaining, the prelim is left on for schedule on October 28th.
All right.
At 9:30.
Thank you.
Thank you, Mr. Nichol.
All right.
All right, we're on the record in docket 22-02653. People, the state of Michigan versus Kendrick Watkins. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender. Here on behalf of Mr. Watkins, I'm filling in for Stephen Feigelson, who's the attorney of record. Mr. Feigelson sends his apologies, Your Honor. He's in a trial.
All right, sir, you are Kendrick Anthony Watkins?
Yes, sir.
Okay. This is the time set for a preliminary examination today. Mr. Witzy, what is your understanding of how we're proceeding today?
My understanding is the defendant is going to be waiving the 21-day rule. I'm requesting an adjournment so he can retain counsel. People have no objection to that. Also, we have our right to a prelim. I would request that the prelim be reset sometime after November 1st. I have an officer who will be on vacation until that date. I'd like him here for the prelim.
Yeah.
All right, Mr. Sarts, is that your understanding?
Yes, Your Honor. My client is banged up. So
Right.
is it okay if he sits?
Absolutely.
Thank you.
Right.
Yeah, that's correct, Your Honor. Mr. Watkins wants to retain an attorney. Physically, he's in pretty rough shape as well this morning. So he's agreeable with adjourning his timeline. We'll do our best to work around the potential audio issues because it is tough for him to talk right now.
All right. So, sir, I'm going to walk you through. You have a right to a preliminary examination within 21 days for your arraignment date. Your arraignment date was on October 2nd. Okay, sir? And that preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime in this file. Do you understand that, sir? In the probable cause hearing, the preliminary examination, which you have a right to within 21 days, at that hearing, which is a probable cause hearing, the prosecutor would bring witnesses and they would testify against you to prove that in this case, probable cause that the crime was committed and probable cause of the identity of the person who committed that crime. Do you understand that?
Yes.
Okay. You'd of course be represented by counsel, and counsel would have the opportunity to cross-examine any witnesses and contest any charges brought against you. Do you understand that? All right. It's my understanding you wish to waive your right to a prelim only within that 21-day period. You're not waiving your right to a prelim just within that 21-day period. My understanding, the reason is you want to seek counsel for yourself. You want somebody other than the public defender's office. Is that correct?
Yes, sir.
All right. So do you waive your right to a prelim within 21 days today?
Yes, sir.
All right. I find the waiver to be knowing, voluntarily, and accurately made. Prosecutors always also waiving their right to a prelim within 21 days. We're going to reset this prelim, and we're going to allow you to seek your own representation in this case through whatever means. All right.
Yes, sir.
All right. So let's get a new date, and with that date, with the notice, make sure your new lawyer has that date because it's important for him. All right. All right. So after November 1st, you said?
Yes, Your Honor.
All right.
November 3rd at 9.
So we will set it for November 3rd at 9 a.m. He waived his 21-day rule. You're going to seek legal representation other than the PD's office. All right, anything else for the record, Mr. Wisty, in docket 22-02653?
No, Your Honor.
Anything else, Mr. Sars, concerning this case?
Nothing further, Your Honor. Thank you.
All right, Mr. Watkins, we'll see you back here on November 3rd at 9 a.m. Make sure you give that date to your new lawyer, okay? All right, thank you. 22-00750. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Kelly on both of these files.
And sir, you are Michael Kelly?
Yes, Your Honor.
All right. This is the time set for a prelim in this matter. Mr. Wisty, how are we proceeding?
Your Honor, we request an adjournment. A week should be sufficient. We believe we're very close in reaching a plea resolution at the misdemeanor level.
And Mr. Goodrich, that's your understanding?
Yes, Your Honor.
All right. I see that the waiver was already done in this case, I believe. Because this is arraigned on March 16th, so the waiver was done. Mr. Kelly, your understanding, we're gonna adjourn this to a date. What are we looking at?
Next week would be sufficient.
A week or two?
Yes,
like
sir.
next week, in order for the attorneys to keep trying to resolve the case?
Yes,
All
sir.
right. Do we have a new date for prelim?
Do they want it next week or the following week?
The next week or the following week?
I would always ask for the following week in case something goes wrong.
Just in case?
I believe the defendant may be incarcerated. He may have a different opinion.
All right.
You know, either week works for us, Your Honor. He is going to be incarcerated on another matter.
All right. So let's do 2 weeks, just to be
Let's do
safe.
November 3rd and
Okay.
9.
So it'll be November 3rd
Yes, at 9.
at 9 a.m. And that'll be on both files, on file 22-00749 and 22-00750. We'll adjourn to November 3rd at 9 a.m. Anything else for the record, Mr. Wiston?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor. Thank you.
All right, Mr. Kelly, we'll see you here on November 3rd,
Thank you,
okay?
Your Honor.
All right, thank
Nice
you.
meeting you. I've been in here a couple times, see you, always seen different judges.
Okay, well, you'll see me from now on.
Yeah.
All right.
You gotta go with him. Oh, yeah. Don't take off on it. You don't get to take yourself. Okay, I know the way.
Weekend, Wendy.
Thank you, you too. Jake,
Am I gonna see it at 3?
Jake, don't forget Zoom.
A Zoom at 3?
Zoom at 3.
Okay, all right. Thank you, Mr. Goodrich.
I don't know about this work on Monday, but we'll give it a shot. How's that?
Doesn't hurt, although they're kind of asking for magic at 11:20 to do a writ for Monday.
But I would really like to get this case off. It has been on there for a long time.
Mr. Goodrich, have a nice weekend.
All right, you too.
All right, take care. Look at that.
Done. Before lunching.
Oh, I get to take a lunch and all set.
Jesus, and you'll end up being pregnant.
All right, so we're going to update. I see the sanctions for technical violation. I wrote all those down. I don't think I've put anybody in jail for a technical violation.
You never put anybody in jail.
I
except
tried,
for the
though.
one that ran, and I didn't go so well.
And how'd that go? Not very well.
All right. I have all these writs for you to sign. Just a
All right.
second.
And then what we're gonna do is we're gonna laminate these 4.
You want to laminate it?
Yep. And this one, you can add legal services numbers on to that one. That'll be. Now what I've got to do is I gotta find that.
Oh, this is the thing I made for you.
Yeah.
Oh,
I
look
just,
it's back.
when we do a misdemeanor plea, we really do a felony plea. I just do the same rights just because I just want to get used to doing the whole thing.
You need to be sure to log off everything. I know that you will
Oh,
have
yeah.
to